welcome Katharina Reuer.
Thank you. Yeah, welcome to everyone. Speaking about accidents, like the guy just before. I don't have a broken arm, but I have to admit it. I just broke my zipper. I'm sorry. So please ignore that my zipper is open. I don't know how that happens, but it's really good timing. Yeah, I want to talk about a legal topic, and this is, from my experience, is usually a bit boring. But however, I try not to bore you. I think my colleagues already talked about legal challenges of artificial intelligence yesterday, and I want to talk to you about something that is less new, or let's say less future, but also very important, and a subject that has been developed enormously by the case law in the last 10 years, and that is the use of trademarks online. And yeah, come back to that. The development of the trademark law during the last 10 years has especially been influenced by the use of trademarks online. And the interesting question always is, can I use third-party trademarks for my own marketing? And I want to give you a really brief guidance on that questions. So let's start with the most important legal principle with trademarks is the trademark functions, and the trademark protection enables the trademark owner to protect his interests, and his interest is to ensure that his trademark function can fulfill its functions. And the most important function of the trademark is to guarantee to the consumers the origin of the goods or services, so the function of indicating the origin. For example, if you see 3 stripes on my sneakers, you know that this is an Adidas shoe made from Adidas. So the very famous 3 stripes mark indicates the origin, and it comes from the company Adidas. So that is the function of indicating the origin. We furthermore have 4 other functions of trademarks which are nowadays legally acknowledged. That is the function of quality, the function of communication, of investment, and of advertising. From my point of view, however, trademarks always have a pilot function, because they navigate the consumers through the internet in order to find your products, in order to find your websites. So the question is, what is your aim of using your own, or more importantly, third-party trademarks in the internet? And as you probably already know, your products can be found on the internet by consumers. So, and how do you do it? How do you navigate through the internet? And you do this by search engine optimization and by the targeted use of keywords, AdWords, and meta tags. So you usually use trademarks as keywords or AdWords. And I have here this overview to show you how the law distinguishes between the different types of use of trademark. This is really important to put it in a legal frame. You probably already know what this all is, what a meta tag is, what AdWords are, and what keywords used in an app store are. However, the important difference is that meta tags are used to influence the generic search results. You know that Google distinguishes between the ad block, the advertising block, which is influenced by the AdWords, and the generic hits, the hit list. So the meta tags are hidden in the source code of your website, and they are found by the search engine crawlers, and they are of course not visible for normal users. And this is the only area where you have only generic hit lists. All the other keyword use is commercial use. You have the AdWords, And it's another important legal fact is that the keyword is always defined between the provider and the advertiser. So between Google and the advertiser, Google and you. It is also not visible for normal users. The keyword used in the App Store is really similar. Here the keyword is also defined between the app developer and the App Store. So between Microsoft or Google, whatever. And it's a little bit different with keyword use in online shops or trading platforms like eBay, Amazon, Zalando. Here, the keyword you use is defined by the online shop itself. And it's usually algorithm driven. So it's the platform merchants who use the keyword. Yeah, so I have some examples to make this a bit more visible for you. This is what you all know. This is the ad block. It's marked with Anzeige, advertisement. This is the paid ad block. And here you have the generic hit results. So when you enter Nike, you get Nike keyword advertising and generic hit lists. And the question is, are you allowed to use a third-party trademark for your own keyword advertising marketing campaign? And this is the really great thing of the development of the law in the past years, because the answer is yes. You can use a third-party trademark. For example, Nike can book the keyword Adidas for its advertising campaign, for its paid advertising campaign, for the keyword advertising. This is allowed, but it's only allowed under certain conditions. It's allowed as long as you don't infringe the function of origin of the trademark. And this is guaranteed as long as the protected trademark is not used in the advert itself. So if Nike wants to buy Adidas as a keyword, Nike needs to ensure that the ad, the Google ad, doesn't include the Adidas trademark. And furthermore, you have to ensure that it's not displayed in the domain, in the advertising link, and also that it's not included in the target domain. And you also need to clearly identify the advertiser, in our case, Nike. You need to make sure that this is a Nike advertising. And what I already said, it needs to be in the advertising block, really separated from the list of the generic search results. This is the basic principle. If you fulfill all these requirements, you can use foreign trademarks for your own marketing campaign. Yeah. So time's running. So this is an example of how you use meta tags. And for today, I would just like you to remember that you are not allowed at all to use any third party, any foreign trademarks as a meta tag for your own website. Never do this. This is strictly forbidden. I brought you a case, but I'm afraid time's flying. This is an example how you can use keywords, trademarks, also in app stores. This is the list, the result list, the hit list you get when you enter the search term in the search block. And the question is, are you allowed to use third-party trademarks here for presenting your app in an app store, or is that a trademark infringement? Are you lying as an app vendor if you do this? And the famous case we had here is between Elite Partner and Parship. And Elite Partner bought the keyword for his own Elite Partner app, Parship. So when you entered Parship in the App Store, you not only got the Parship app, but you also got the Elite Partner app as a search result, and you even got it in the first place. So the question was, is that a trademark infringement? And here the difference between the advert case and the App Store is that you clearly see this one is the Elite Partner app because the logo is very special, the name Elite Partner is displayed, and then you have the next search result with the clear logo of the Parship app, and you'll know this is the Parship app, and that is the Elite Partner app, so there's no confusion about the companies, no confusion about the signs, the trademarks, so you don't infringe the function of origin of the trademark. So it's no trademark infringement, but it can be an infringement of competition law. And the question we raise is that what you do a targeted impairment of the trademark owner, of your competitor? Does Elite Partner, in our case, really try to push away the Parship app from the first place of the result list? And the courts tend to say yes, if it always results that the Elite Partner app is shown in the first place, although the user is looking for the Parship app, then we have an infringement of competition law. So you have to be careful doing this. This is what I meant with internal search engines from online shops. Here you see Zalando has its own search engine, and Amazon also. And what nowadays every search engine does is they provide you with suggestions, with proposals of which product you might be looking for, which trademarks you might be looking for. Like here, in this case, Amazon. When you enter Nike, you get a proposal for Nike shoes, shirts, and whatever. This is called the autocomplete function, as you probably know. And the questions you have to raise when you want to use trademarks in online shops is the autocomplete function a trademark infringement? Is it a trademark infringement if also products of other brands are displayed next to the products you are looking for? And no, I know time's running. And this was the last slide anyway. Yeah, I know this was a really quick ride, but law is complicated, and I just want to sensibilize you for where you may have some traps, some legal traps.
I'm actually really impressed because I haven't done one of those 12 minutes me presentations myself, but I can imagine that it's really hard to putting a really complicated topic into only 12 minutes. And I think you managed not only to talk about your topic itself, but also to give us some basic information so everyone can understand that what you're talking about. So yeah, thank you for your time, putting so much effort into the whole presentation. And for sure, it's really hard using 12 minutes only, but that's why we have another 6 minutes for you to ask questions, if there's anything else which you want to know. Otherwise, I can start with a question whenever you have one. You just raise your hand. Okay, nice.
Hi, I'm Axel. I would like to know, I'm not in the legal side at all, but doesn't it depend a lot on local law that you always have to make sure that you're complying with all the different regulations in every country, or how does that actually work?
Yeah, this is, but the trademark law, luckily, is harmonized European-wide. So we have a European trademark regulation who gives guidance, and every country has to stick and to apply those rules, and they actually all did it. Also, all national trademark law is basically the same in Europe.
For the American market, for example?
No, the American market is different. Yeah, so we don't do US law at all. Yeah, so we have our partners in the US who are doing it. Yeah, I mean, I think we all stick to basically the same principles, but the details are different. Yeah, like the law system, the US have the common law system, which is already different than our system. Yeah.
There is another question from Michael.
Yes, thank you. What about this kind of versus advertisements, like for instance BMW did recently with Mercedes when Sergio was leaving and they saw him driving off in a BMW, where you're saying my product is better than X, Y, that.
Yeah, this is the subject of the so-called compared advertising, where you compare trademarks, and you normally don't infringe the function of origin because the consumer realizes that you have two different companies and two different products, and that you are in a situation of comparison. But the question you have to raise there is if the way you compare the products is detrimental to your competitor. So there are also very clear rules what you can do and where the borders are. And yeah, the general rule is don't cause harm to your competitor. That's the general rule. Yeah.
Does this answer your question?
Yes.
Amazing. There is another one from Lars.
Yeah, hi. Thanks for your talk. Just one question. Is there a problem? You mentioned elite partner and Parship, but they stick together in a group?
No, but they weren't in former times. We had a lot of nice legal disputes with them before they joined.
But now it's no problem.
No, none. As long as you're one company, you can do, of course, whatever you want with your trademarks. Yeah.
Hi, thank you for your talk. I got one question to the anti-competition law. I think an example there is the App Store, Spotify, and for example Amazon with their own products. So how is it there when you rank your own products like above other products, although they might hit like better results in the search?
Yeah, it's not easy to give a general answer to that question, because every algorithm of every online shop works a bit differently. And first of all, you have to raise the question: how much can you, as an advertiser, can you influence the algorithms, or is it the provider of the platform who is creating and building the algorithm who is liable for the ranking? And we don't really know exactly how everyone does it, because of course the providers don't really want to explain in detail how everything works. So we always have to assess legal questions on the facts that we have. But as far as you can see that somehow the competitor is able to influence the ranking by using other or competitors' trademarks, and if this results in that's what I said before, in that your competitor is always pushed away or ranked lower, and you might have this unfair competition problem. But there's also always a question of evidence, unfortunately, or luckily, depending on which side you are.
I have another question.
Yes.
I used to work in a co-working space for some months, which is called Mindspace. And when I Google it, I ended up having results in which the competitor WeWork was not only on the second but on the first place of the Google results.
But that was the generic? Generic hit list, not the ad block.
I'm
I guess.
not sure.
Yeah.
So you're saying it must have been the actual list, because for the ads it's not possible. Because that's what I was wondering.
The summary is it would have been legal if it would have been the advertising block and saying, this is an ad, this is the Anzeige, this is an ad, and if they would only stick to their own products and own name and not use your trademark in the ad. But if they appear in the generic hit list, we would have to look how they do it. And if they, for example, use your name in the source code of your website to be found by the crawlers, that would be a trademark infringement, probably, yeah.
Well done, good timing. Thank you so much for coming.